Hello and welcome to the LLG Grapevine podcast. You're listening to Helen McGrath, LLG's Executive Director of Policy and Governance, and Dennis Hall, LLG Bulletin Editor.
Hello, everyone.
I'm very excited this week, Dennis, because the end of this week brings the spring conference being held in Leeds. And you're going to be there, I understand.
Indeed, I am, yes. Looking forward to it very much.
Fabulous. Well, we've got some great speakers lined up and a brilliant exhibition, and we will just have to see if our CEO makes another dazzling appearance in her green sequin suit. We also have the LLG Awards, Dennis, and that's always a joyful occasion. But back to the business of the day. What have you got for us, Dennis?
Well, inevitably, it's that general election that's on our minds. And here's a question. What exactly happens to Parliament and to government and to MPs once a general election is announced? In effect, what is the effect of dissolution? Let's take a closer look at this. As we now know, Rishi Sunak has called a general election for the 4th of July. But here's a question. What is dissolution and what's its effect? Well, dissolution is the formal term for the end of a parliament. It occurs ahead of a general election for a new parliament. Dissolution brings a parliament to a close, but contrast this with prorogation. Prorogation signals the end of a parliamentary session, the parliamentary year in effect. And dissolution brings nearly all parliamentary business, including most bills, and all motions and parliamentary questions to a close. The main difference between dissolution and prorogation is that after prorogation, the same parliament, including the same MPs, reconvene, whereas after dissolution, an election takes place and a new parliament is formed. So what does dissolution mean then for MPs? Well, when a parliament is dissolved, every seat in the House of Commons becomes vacant, and this means there are no longer any MPs. Those who were MPs before dissolution cease to represent their constituents and lose access to parliamentary facilities and resources, and they no longer refer to themselves as members of Parliament. So what does dissolution mean for peers? Because members of the House of Lords are appointed rather than elected, they remain in their roles throughout the campaign period. They, unlike MPs, are still allowed in the parliamentary estate. But no more parliamentary business will occur until after the next election has finished and the new parliament has begun. What does dissolution mean then for parliamentary business, including legislation? When Parliament is dissolved, all unfinished parliamentary business falls, including any bills that have not received royal assent. Bills cannot be carried forward from one parliament to another, reflecting the legal convention that no parliament can bind its successor. This differs from prorogation, where the government can choose to carry over bills between parliamentary sessions. To prevent unfinished parliamentary business falling, governments will usually try to complete as much unfinished business as possible in the time between an election being called and Parliament being dissolved or prorogued, this period being known as the wash-up period. And there are several articles in Bulletin 19 on what's happening with bills right now. Now, what does dissolution mean for government? Government ministers remain in post and continue to run their departments when Parliament is dissolved. They are only replaced when a new government is formed following a general election. And finally, let's turn to pre-election activity. By convention, dissolution also marks the start of the pre-election restrictions period, historically known as PERDA, the time during an election campaign when there are restrictions on what government can do, both in terms of initiating policy and in the use of official resources. During the general election, these conventions also cover local authorities, as you mentioned last week, Helen.
Yes, Dennis, and depending on when the notice is issued by local authorities, calculating the deemed date of receipt of the writ, local authorities will either be in their heightened period today, which is Monday the 3rd of June, or at the latest 4 p.m. on Tuesday the 4th of June, by my calculations. So feel free to write in and tell me if I'm wrong. Now then, there are a lot of inquiries going on at the moment, but I would like to turn back to the COVID inquiry, which we haven't mentioned for a while now because we've been far more focused on the Post Office inquiry. And I'd like to raise the testimony of Simon Case. Now, he was the lead civil servant with responsibility for COVID policy at the time of the Eat Out to Help Out scheme. And he said in testimony that he hadn't been made aware of the scheme until it was announced. He also said that Boris Johnson's number 10 had been involved in the, quote, worst governing ever seen in the UK, and how difficult it was. He said at the time that good people were working incredibly hard in impossible circumstances with choices where it seems there was, quote, never a right answer. He also gave evidence, and I'm going to quote him again here, that good people were just being smashed to pieces. That's what I saw. And he confirmed a culture of fear around Dominic Cummings. Now, we've seen, haven't we, in the local government sector, that where poor culture exists, fear of speaking out or being blamed prevails, and siloed decision making is the norm, and then governance fails spectacularly. And I can only imagine that in a crisis that is magnified. So let's just take a look at where we are with the timetabling of the inquiry. We're currently on module 8. That launched on the 21st of May, and that's looking into the impact of the pandemic on children and young people. And I've reported previously that children's ministers have lamented the lack of voice for children during decision making throughout the pandemic. And we've seen certainly impacts in relation to school attendance that's happening now, and an increase in the rise of mental health issues facing younger people. So this module will investigate the impact of the pandemic on children across society, including those with special education needs and or disabilities. And it will consider a diverse range of backgrounds, the impact of decision making on children and young people, and as I've just alluded to, the long-term consequences of the pandemic. But just a reminder here that public hearings in the inquiry are not due to complete until 2026. So we're a long way off receiving the conclusions and findings of the inquiry. Now, in other news, you've been looking at limitation periods, Dennis.
Yes, I have, this time in the context of procurement. You know, procurement is regularly in the news nowadays, new policies and new legislation. And now this important legal case has come along that clarifies the law on limitation periods for challenges to contract awards. Here's the detail on this. The High Court has handed down an important judgment, providing extensive guidance on the correct interpretation and application of a number of aspects of the rules governing limitation in respect of challenges to the award of public contracts under the Public Contracts Regulations 2015. In the case of Oracle Security Services and Barts Health NHS Trust, the claimant, Oracle, commenced proceedings alleging that an NHS trust had effected an unlawful direct award of a public contract by purporting to award and backdate a call-off contract under a framework agreement to a contractor who, in reality, had been directly appointed without a lawful procurement process. The defendant trust applied for summary judgment and strikeout of the Oracle claims on the basis that these were time-barred because the evidence indicated that Oracle had acquired actual or constructive notice of the facts on which the allegations of breach of the regulations were founded, more than 30 days before the claim was commenced. Both Oracle and the Trust launched powerful arguments to support their legal positions, and the detail can be found in the bulletin posting. Consequently, the court's judgment provides invaluable guidance on a number of points regarding the interpretation and application of the limitation provisions of the 2015 regulations. Two conclusions that will be of interest to commercial and procurement lawyers. The High Court held that, 1, in calculating the 30-day limitation period for the purposes of the 2015 regulations, the day on which knowledge is first acquired counts as day 1 of the relevant period. That is to say, day 1 is not discounted. And 2, For the purposes of applying the limitation period in the regulations, a solicitor conducting litigation on behalf of their client is acting as agent on behalf of their client, and therefore the client will be fixed with the knowledge of their solicitor for the purposes of litigation from the date the solicitor actually acquires the relevant knowledge. Now, this judgment will be of considerable interest and importance for those litigating public contract challenges in local authorities. Helen.
Well, I think procurement is at the foremost of local authority legal minds at the moment, or rather it should be, if it isn't, due to the sheer amount of changes coming into effect in October. Now, there's a lot of information in the bulletin on this, including government guidance, the define phase and plan phase. Of course, Wales will be making regulations off the back of the Act, which local government in Wales is still waiting for. Now, in other news, the Leasehold and Freehold Reform Act has received royal assent. There was some suggestion that Labour might not support the bill due to certain parts being watered down, but it did get through, and it does the following. It makes it cheaper and easier for people to extend their lease or buy their freehold, so leaseholders pay less to have more security in their home. It increases the standard lease extension term to 990 years for houses and flats, up from 50 years in houses and 90 years in flats. So leaseholders can enjoy secure ownership without the hassle and expense of future lease extensions. It gives leaseholders greater transparency over their service charges by making freeholders or managing agents issue bills in a standardised format that can be more easily scrutinised and challenged. It makes it easier and cheaper for leaseholders to take over management of their building, allowing them to appoint the managing agent of their choice. And it makes it cheaper for leaseholders to exercise their enfranchisement rights, as they will no longer have to pay their freeholders' costs when making a claim. It extends access to redress schemes for leaseholders to challenge poor practice, and the government will require freeholders who manage their building directly to belong to a redress scheme, so leaseholders can challenge them if needed. Just to note that managing agents are already required to belong to a scheme. It makes buying or selling a leasehold property quicker and easier by setting a maximum time and fee that for home buying and selling information, and it grants homeowners on private and mixed tenure estates comprehensive rights of redress, so they receive more information about what charges they pay and the ability to challenge how reasonable they are. So the controversial marriage value has gone for leaseholds under 80 years, but ground rents were not capped as initially considered, so that's not been taken forward in the Act. Further, the Act now is not in effect, and the last guidance from the government suggests it will be 2025 to 26 for that to happen, with reforms being implemented in stages. So it will be for the incoming government to decide the next steps. So it's worth noting that the actual reform is still some time off. Dennis.
Thanks, Helen. We often look for a well-being topic where we can, and a recent Law Society Gazette article recognises the importance of recognising neurodiversity in the workplace and gives a good example of one far-thinking firm that provides support to its employees. Here's more on this topic. An international legal firm has pledged up to £3,000 for each staff member to access special neurodiversity assessment and support. Pillsbury Winthrop Shaw Pittman, which has around 60 staff at its London headquarters, claims to be one of a handful of UK firms to provide such a dedicated initiative. Eligible employees will be able to book private appointments with a designated GP clinic, with the firm covering the costs. And the firm will also reimburse the cost of a further appointment for anyone referred to a specialist and offer time off for people to attend in person. And the package also comes with a commitment to providing comprehensive workplace support for those managing neurodivergent conditions. Nadia Barazai, partner and head of diversity and inclusion, said it is estimated that 1 in 7 people are neurodivergent, and it is essential that neurodiversity doesn't act as a barrier to success. That is why, she said, they are pleased to be able to offer this important support package, keeping pace with recent developments in understanding how neurodiversity can impact individuals at work. And as importantly, the package will serve as the bedrock that upholds a culture of greater awareness and understanding of the various practices and policies needed to ensure that everyone is able to reach their full potential. Now, law firms have increased their commitment to adapting workplace conditions for neurodivergent staff, but there appear to be several gaps where people do not feel supported or are unwilling to say that they are neurodivergent. A survey carried out this year found that more than 3/4 of neurodivergent lawyers have not disclosed their condition to employers to avoid discrimination. Almost half of respondents said they had experienced discrimination in relation to their neurotype in legal education and training, increasing to 64% for dyslexic legal professionals. Around 40% have been refused or not provided reasonable adjustments during their legal education and training. And a similar proportion of legal professionals said they had been denied reasonable adjustments in their workplace. This initiative is an important step, and all employers should be looking at this as an example to consider. Helen.
Well, neurodivergent individuals can bring so many skills to the workplace, and it's essential, Dennis, that employers recognise the need to support their employees and look at neurodiversity in a positive way. Now, finally from me, and a new one on me really, drainage board levies. So what are they? Well, internal drainage boards are statutory bodies set up to manage water levels in a defined district for the benefit of land managers, householders and industry in that area, and they're funded by agricultural occupiers through the drainage rate and local authorities through a levy. Now, the other week, the LGA's Vice President, Baroness Taylor of Stevenage, asked a question in the House of Lords on the pressures councils have experienced due to the increasing internal drainage board levies and called for a long-term solution. Responding to the debate on behalf of government, Baroness Scott of Bybrook acknowledged that while the Department for Levelling Up Housing and Communities has given an extra £3 million outside the local government finance settlement to the 15 worst affected councils, the scale of costs being passed on to certain councils is not sustainable. Now, Baroness Scott actually said, and it's worth quoting her here because it really places this issue into contextual focus. My lords, the 3 million does not touch the sides. Councils are charged this levy to manage water levels in their area. Since 2016, they've been expected to fund it through council tax. The financial impact shows that it has increased by almost 11 million in 2 years, beyond the council tax capping limit of 30 authorities involved, such as Boston, where the levy consumes 58% of the council tax, and Great Yarmouth, which saw 91% of its council tax increase consumed. Councils have been told repeatedly that the government are looking for a long-term solution. So where is that solution? When is it coming? And will the government meet the representatives to determine a solution before the end of the financial year? So I understand that the LGA supports a revised approach to the current funding method, but the financial amounts, Dennis, that's staggering. And on that note, you can read more on the items discussed today and many more besides by going to bulletin number 19, available on the LLG website now. So it's goodbye from me.
And from me too.
Have a good week.